So, hi everybody. I'm glad to talk to you via Zoom and YouTube. My name is Thomas Hoeren. I'm responsible for our LDA education. I want to talk to you today about the second part of the Data Act. There are important issues which are necessary to discuss. Let me just check for my slides. Here it is. So, you've seen the Data Act is very special. It's not impressed by other similar regulations in Europe and United States. It's a unique piece of legislation. I have checked all the diaries and registers for knowing who has done it. There must be a secret inventor and creator in the Commission who started to think about this idea of giving access to data. We have spoken in the last session on the regular approach to think there should be free access to data stored in Internet of Things. So the end user might get free access, or he might grant free access to this data for third parties as well. That's all regulated in Article 2 to 9. I want to talk now about further problems in the regulation. One of the big topics is unfair contract terms. That's regulated in Article 13, I believe. There's a special regime created for checking unfair contract terms that cannot be compared. I will show that to you in a minute. To German unfair contract terms regulation. So it's a brand new world of different regimes on the legal control of unfair contract terms. I will first try to explain what is the general impact of the Data Act on that matter, then the relevance of unfair contract terms in B2B and B2C, and then talk about the aim, analyze key articles and scholarly perspectives. The legal background first. We are just talking again about the Data Act, which has a focus on fair access and fair use of data. It has a lot of links to other regulations, such as the e-consumer protection directives or EU contractor law. In Article 13, you find the unfair contract terms regulations for business-to-business contracts. Because Article 13, please check your legal text. Perhaps you can stop the recording for the purpose of taking your textbook and check Article 13. Because Article 13 prohibits contractual terms that are unilaterally imposed by an enterprise on another enterprise, and that grossly deviates from good commercial practice. So it has nothing to do with consumer protection. So it's a special tool for B2B contracts. The criteria for prohibiting these contractual terms is imbalance lack of transparency, no negotiations. It is only applied if the contract is not individually negotiated, so it must be unilaterally imposed by an enterprise. Here you find references to two very good articles on that topic. You will find what this reference means at the end of this lecture. Ms. Grave, who is a professor from Leiden, is one of the big guys in the area of Data Act and unfair terms. And she has written a joint article together with Hulsowek, another very brilliant and highly known law professor. Josef Drexel is representing the Max Planck Institute for Innovation for Intellectual Property Right. Article 13 not only generally prohibits unfair terms, but it consists of a blacklist and a gray list. Certain clauses are automatically deemed unfair, so they are listed on a blacklist and they are devil. So that's dead. Then we have a gray list. These clauses which you find on the gray list are presumed unfair unless proven otherwise. For instance, if you close a contract and you excessively limit liability, that would be on the gray list. The impact with Article 4 to 11, the obligations on data holders for making data accessible, are really unclear. So Article 13 stands as a kind of monolith and has no direct references to the general obligation to make data accessible. It was made in the last minute to have a system which helps the Commission and the member states against two powerful cloud providers. Then the relationship again with GDPR and DMA is as well open for discussion. So there's an overlap between antitrust law and the Data Act. So let me just check where we are. There we are. The question also is this: what is the relationship between consumer law? Because we have unfair terms directives of the Commission, famous directive from 1993. It's very similar in defining substantive unfairness, but the difference is these Article 13 is only applicable in B2B relationships, while the consumer law applies only to consumers. In general, there is a lot of criticism, and people don't understand, isn't there a high risk of overregulation in B2B contracts? And this creates also a kind of legal uncertainty about what can be drafted in an agreement. And the question is, how can you enforce your rights For instance, we should talk about fines and sanctions that are foreseen if you are violating Article 13. There's a sanction called fine. But what is happening with the overlap, for instance, antitrust law, what is happening with the overlap to general unfair contract terms regulation, that needs to be discussed in the future. To show you certain examples, first case, there's a sentence in a contract saying the data holder may unilaterally modify the scope of shared data without notice. That is, for instance, according to Article 13, a clear violation of fairness and transparency, so it's likely to be blacklisted and forbidden. Take another example. The data recipient must indemnify the data holder for all third-party claims, regardless of fault. That is a very unbalanced risk allocation and causes a lot of problem for the data recipient. So it's likely to be graylisted and presumed unfair. Third clause, the recipient is prohibited from using the data beyond 1 year, while the holder retains permanent use rights. That's a grossly deviation from good commercial practice. It's not listed in Article 13 as blacklist or gray list, but it shows a significant imbalance, so it might as well be forbidden. Then we choose another case. The scenario is quite easy. A small business contracts SaaS, a service, software as a service provider for analytics services. The contract contains a clause, all user interaction data shall be owned and exclusively used by the provider. The client shall not access any analytics or export data. If that clause is made unilaterally and not negotiated, Article 13 applies, and this clause is likely an unfair because it lacks reciprocity and transparency, so it may be void according to Article 36. So the Data Act insofar stresses the fairness in the digital contracts business. Article 13 is totally new, but it's highly controversial, a new approach to B2B fairness. And it's important to balance flexibility and protection. The Commission has already said that they will publish a kind of model agreement for showing how a balanced and flexible contract can be drafted. So we need to wait to see what the Commission is planning and drafting as model contracts. Here you find the references to the articles. If you want to read them, just use copy and paste and ask Google for search engine for finding the relevant data. In addition, I want to talk a little bit more about the relation between Article 13 and the German regulation in 305 to 310, because Germany already has a very extended system, a very old one, traditional system of controlling unfair contract terms in business to business and business consumer. The difference between Data Act and this approach in the BEW is the Data Act only applies to non-negotiated B2B data sharing contracts, while 305 to 310 applies to standard form contracts, both B2B and B2C. The Data Act defines unfairness as a deviation from good commercial practice and being imbalanced and lacking transparency, while Section 307 of the BEB prohibits unreasonable disadvantage contrary to good faith. It needs to be decided by the courts what these standards mean. For instance, what a good commercial practice in Data Act means. Our BEB has this idea of blacklist and graylist as well. There's a graylist in 308 and the blacklist in 309. That's similar to the instrument in the Data Act. So you could see where the Commission is coming from and where they have taken this idea from for blacklist and graylist. A very important difference is the one that the Data Act only applies to unilaterally imposed and non-negotiated terms, while the German law generally asks, is a term standardized? It doesn't matter if and how the standard term is negotiated. And the Data Act is informed by the member states and by private enforcement. That needs to be seen in the future, whether we apply this principle of Article 13 as part of our unfair trade law or within our unfair contract term system in Germany. In German law, it said that these regulations can be enforced by civil courts, and it's allowed for consumer and consumer organization to sue, or even a competitor can sue if German unfair trade law is violated. That needs to be shown whether this approach of allowing consumer and competitor lawsuits is also relevant for the Data Act. There you find articles that you can read. I would recommend, for instance, Ms. Wenderhorst, a very intelligent colleague of mine from Vienna, who has checked all these questions on data access and control. Third topic. We have in the Data Act as well a separate chapter on switching between data processing services that applies, for instance, if you want to skip your relationship with Microsoft and change your cloud contract in advance of other competitors. You should be free to skip any cloud contract, any SSAS contract, and get support for that switch. So what is covered by these regulations? You see it's mentioned in the 23. There on the bottom, you see all the relevant articles. This data processing services include networks, servers, storage systems, operating systems like Microsoft, Windows, or cloud-based software like Azure or Amazon. It applies as well to applications and platform. The goal is allow an easy migration without login, without any disturbances and problems. So the great idea is switching must be supported. Providers must allow switching to similar services. Providers must as well remove all technical and contractual barriers against switching, and they have to provide clear contracts on switching support. You see the aim of the Commission when you see the very short time limit. The maximum switching period, according to the Data Act, is 7 months. So you can very easy switch from one provider to another, at least in the maximum time of 7 months. A one-time extension is allowed, but after this 7 months, you are free. And very important, during the switching time, you get the right to get continued service provider, so that is technically very easy to switch. If you take Google, for instance, and you want to switch from Google to Azure or to Apple, it's quite expensive. All these switching fees are forbidden after the 12th of January 2027. In the time until that date, switching fees remain valid, but they are only allowed on a reduced basis. That means cost base. So you can only ask for a reimbursement of your costs as Google, and you have to clearly inform the users in advance. You are only allowed to use standard formats like XML. That means you have to maintain semantic interoperability, so that it's easy to change the provider. And the security and continuity has to be guaranteed. So you have to ensure data to security and service integrity. You have to provide upgrades so that the user is very easily has the latest state-of-the-art for security. And you have to prevent disruption. So if you're switching That should all be not a problem from a technical point. Why is the Commission focusing on that? Because they hate vendor lock-in. That means a technical surrounding which prohibits these changes. That should be done very easily. The user has a right to get support during the switching time, and he has a right to have his control and to get a really efficient access to his data, so that the Commission at least at the end wants a good marketing competition in the market of cloud provider or other software providers. I've integrated several cases we can read at home, 2 cases for your work and for preparation. I will change now for a 4th topic. That's the relationship between the Data Act and database rights. Now you can think back to the time of the winter term when we have discussed about the database protection right granted by the European Commission in a separate directive, which has led to a lot of changes in copyright systems throughout Europe. So every member state has, since 20 or 30 years, has to integrate a system for protection of the compilation and structuring data. That has, for instance, been done in Germany in our Copyright Act, but that causes a lot of problems with the Data Act, because the Data Act says we want in Europe a free access to and a free use of data, especially Internet of Things generated data. And if somebody could say, I have a legal monopoly in data, that conflicts with the idea of free access to data. So, Article 35 therefore said the sui generis database right cannot block free access to data under the Data Act. That is preventing misuse of IP rights to restrict secretly the legitimate data sharing ideas. That means the sui generis rights still exist, but it's overwritten by Data Act obligations. So even if the data are in a protected database, a data holder must provide access. For instance, imagine a smart tractor company. As a smart tractor company claims database rights over telemetry data. So all the data stored in a smart tractor, that is the object of a claim in database rights. Then, of course, the farmers and third parties are nevertheless entitled to free access under the Data Act, and the database protection cannot be used to block this access. So, another 5th problem. There are regulations on personal data. That is a topic for GDPR. And there are the new regulations on non-personal data. That is exactly the topic of the Data Act. For me, that's very important because if you have non-personal data, then we have a separate section apart from the GDPR, but very similar to the GDPR in Articles 27 to 30, which says that non-EU governments should not try to get access unlawfully to EU non-personal data. So for foreign access must not conflict with EU law, and therefore 28 says the transfer of data, of non-personal data to non-EU countries requires safeguards similar to the GDPR. That means the foreign country, a third country, has to demonstrate that they have an adequate protection of non-personal data compared to the European standard. And they have to notify about, and the member states have to very aggressively enforce their sanction and penalties against these third countries. You can read more in these two articles, which are really well made. Last topic, enforcement and fines. That is regulated in 40 to 42 of the Data Act. Member states must designate one or more enforcement authorities, especially for the problem of free data access, fair data access, and interoperability. The problem is 48 says we will not fix a certain sum. So no fixed fines is defined in the Data Act. It only says 41 penalties must be effective, proportionate, dissuasive, and each member state is free to decide about the correct size. These fines will be made for a failure to provide data access, that's fee 4 to 6, well, as well to Article 13 on unfair contractual terms, as well as unfair lawful international data transfers and non-compliance with interoperability requirements. So the GDPR has a certain very astonishing amount of clear defined fines that is missing in the Data Act, so that harmonization is still a big topic in the member states. So that's my last slide. I hope you liked my quick survey on the additional topics of Data Act. I wish you a very perfect day, and we see each other in the next session. Thank you.